Hey, y'all, and welcome back. This is going to be the final lecture. This is going to be Unit 4D from Separate but Equal to Desegregation. A little bit of a note some of the language here is anarchic and anachronistic and would never be used in the modern day. Um, so I'm not purposefully using words like Negro, etc. They are sort of the zeitgeist of the time, right? So bear with me. Some of these cases were just really hard to read. So anyway, okay. Case one is Strouder v. West Virginia in 1880. It is a 7-2 reversal, and Justice Strong delivers the majority opinion. So remember, this is leading up to the Plessy v. Ferguson 1896 case. Okay, so in West Virginia, a black man is indicted for murder. And they say it is to be observed that the first of these questions is not whether a colored man, when an indictment has been preferred against him, has a right to a grand or a petite jury composed in whole or in part of persons of his own race or color. But it is whether, in the composition of selection or jurors by whom he is to be indicted or tried, all persons of his race or color may be excluded by law, solely because of their race or color, so that no possibility can any colored man, sit upon the jury. So West Virginia had a law saying that blacks could not serve on juries. And so the court is saying, while we're never saying that, a jury should only be composed of black or Hispanic or white, etc., depending on the color of the defendant, um, we're looking here at whether you can just exclude black people from juries in general. And so this is a 14th Amendment appeal, right? The 14th Amendment was the post-Civil War appeal. Okay. And all of these cases are basically going to be 14th Amendment appeals. And they say this is one of a series of constitutional provisions having a common purpose, namely, securing to a race recently emancipated, a race that through many generations had been held in slavery, all the civil rights that the superior race enjoys. So they're still using this sort of white supremacist language. At the time when they were incorporated, this paragraph is pretty disgusting. At the time when they were incorporated into the Constitution, it required little knowledge of human nature to anticipate that those who had long been regarded as an inferior and subject race would, when suddenly raised to the rank of citizenship, be looked upon with jealousy and positive dislike, and that state laws might be enacted or enforced to perpetuate the distinctions that had before existed. Discriminations against them had been habitual. It was well known that in some states laws making such discriminations then existed and others might well be expected. The colored race as a race was abject and ignorant, and in that condition was unfitted to command the respect of those who had superior intelligence. Their training had left them mere children, and as such they needed the protection which a wise government extends to those who are unable to protect themselves. So this disgusting history of the 14th Amendment and why the state has to be involved in helping to protect infantile black people. So again, this is the disgusting language of the time. They go on to say, therefore, the statute of West Virginia, discriminating in the selection of jurors as it does against Negroes because of their color, amounts to a denial of the equal protection of the laws to a colored man when he is put upon trial for an alleged offense against the state. It remains only to be considered whether the power of Congress to enforce the provisions of the 14th Amendment by appropriate legislation is sufficient to justify the enactment of their law. West Virginia must allow black jurors, basically, is the ruling. Okay, we move on to 1886, case 2, Yickwo versus Hopkins. And this is a unanimous 9-0 reversal of the lower court decisions, and Justice Matthews delivers the majority opinion. So, San Francisco has an ordinance stating that San Francisco had the Great Fire, and they're very worried about the construction of their city post Great Fire. And they instituted an ordinance saying that if a building was made of brick or stone, you could hold a laundry in it with no permit. But if a building was made of wood, you had to get a permit from the city to operate a laundry within it. Um, and so a Chinese citizen appealed under the 14th Amendment because what happened is the statistics show that of 280 permit applications, 80 were granted and 200, all Chinese, were not granted. And the 80 permits that were granted were all non-Chinese. Okay, so they sue under the 14th Amendment. And the court says, for the cases present, the ordinance is in actual operation, and the facts shown establish an administration directed so exclusively against a particular class of persons as to warrant and require the conclusion that whatever may have been the intent of the ordinances as adopted, they are applied to the public authorities charged with their administration with a mind so unequal and oppressive as to amount to a practical denial by the state of that equal protection of the laws which have secured the petitioners. This discrimination is admitted. No reason for it is shown, and the conclusion cannot be resisted that no reason for it exists except hostility to the race and nationality to which the petitioners belong, and which, in the eye of the law, is not justified. The discrimination is therefore illegal, and the public administration which enforces it is a denial of the equal protection of the law and a violation of the 14th Amendment. The imprisonment of the petitioners is therefore illegal, and they must be discharged. So they're saying here, not only are Black people protected under the Equal Protection Clause of the 14th Amendment, but so are Chinese. And you cannot set up a discriminatory administrative process. And so, they vote for Yo. Okay, case 3. Plessy v. Ferguson in 1896, one of the most shameful cases in American history. It is a 7-1 affirmation of the lower court rulings, and Justice Brown delivers the majority opinion. So at question here is a Louisiana law that says Black people and white people have to ride in separate train cars. The white people cannot sit in the black cars, and the black people cannot sit in the white cars. And so Plessy brings a 14th Amendment appeal, and the court says, quote, "The object of the 14th Amendment was undoubtedly to enforce the absolute equality of the two races before the law. But, in the nature of things, it could not have been intended to abolish distinctions based upon color. Laws permitting and even requiring the separation in places where they are liable to be brought into contact do not necessarily imply the inferiority of either race to the other, and have been generally, if not universally, recognized as within the competency of the state legislatures in the exercise of their police power. The most common instance of this is connected with the establishment of separate schools for white and colored children, which has been held to be a valid exercise of the legislative power even by courts of states where the political rights of the colored race have been longest and most earnestly enforced. In determining the question of reasonableness, it is at liberty to act with reference to the established usages, customs, and traditions of the people, and with a view to the promotion of their comfort and the preservation of the public peace and good order. Gauged by this standard, we cannot say that a law which authorizes or even requires the separation of the two races in public conveyances is unreasonable or more obnoxious to the 14th Amendment than the acts of Congress requiring separate schools for colored children. We consider the underlying fallacy of the plaintiff's argument to consist in the assumption that the enforced separation of the two races stamps the colored race with a badge of inferiority. If this be so, it is not by reason of anything found in the Act, but solely because the colored race chooses to put that construction upon it. Man, gross. Okay, there is a dissent, though, a strong dissent from Justice Harlan. And justice, and remember, this Plessy v. Ferguson case is the entire establishment of separate but equal. So, you can't use the same schools, you can't use the same transportation devices, you can't use buses, you can't sit in the same spaces. Restaurants can disallow you from eating at them. You can't go into the bathrooms. You can't use the same water fountains. I mean, this bullshit. Um, all came from this Plessy v. Ferguson case. And so Justice Harlan gives a strong dissent. And he says, everyone knows that the statute in question, the 14th Amendment, had its origin in a purpose not so much to exclude white persons from railroad cars occupied by blacks as to exclude colored people from coaches occupied by or assigned to white persons. So he's like, I'm calling bullshit here. The thing to accomplish was, under the guise of giving equal accommodation for whites and blacks, to compel the latter to keep themselves while traveling in railroad passenger coaches. No one would be so wanting in candor as to assert the contrary. If a white man and a black man choose to occupy the same public conveyance on a public highway, it is their right to do so, and no government, proceeding alone on grounds of race, can prevent it without infringing the personal liberty of each. So the arbitrary separation of citizens on the basis of race while they are on a public highway is a badge of servitude, wholly inconsistent with the civil freedom and the equality before the law established by the Constitution. It cannot be justified upon any legal ground. The thin disguise of, quote, equal accommodations for passengers in railroad coaches will not mislead anyone, nor atone for the wrong this day done. All right. Case 4. Missouri ex rel. Gaines v. Canada in 1938. This is a 6-2 reversal, and Chief Justice Hughes delivers the majority opinion. Now, you got to remember, the zeitgeist is changing a little bit, right? We've been through World War I, we went through World War II. Black men served our country honorably and bravely. They served in our factories when we needed workers to produce ammunition and tanks and guns and planes and bombs. Um, um, and so the zeitgeist is changing quite a bit. And Franklin Delano Roosevelt has put in some more liberal-minded justices, and so things are shifting. Okay, so Gaines was denied acceptance into the Missouri University Law School, and he appeals under the 14th Amendment. He had a bachelor's degree from Lincoln College, which is an HBCU, a historically black college or university that was in the University of Missouri system. He applied to law school at University of Missouri because Lincoln College didn't have one. And Missouri law stated that he had to go to an out-of-state black law school and that they would help pay the tuition. But he could not attend a public university in Missouri law school. It was also stated in the documents that he would have been accepted to University of Missouri's law school had he been white. So the court says, in answering petitioner's contention that this discrimination constituted a denial of his constitutional right, the state court has fully recognized the obligation of the state to provide Negroes with advantages for higher education substantially equal to the advantages afforded to white students. So they're still leaning on this, separate but equal, right? And they're really heavily leaning into the equal part of it. The state has sought to fulfill that obligation by furnishing equal facilities in separate schools. It is said that Missouri is the only state in the Union which has established a separate university for Negroes on the same basis as the state university for white students. But, commendable as it is that action, the fact remains that instruction in law for Negroes is not now afforded by the state, either at Lincoln University or elsewhere within the state, and that the state excludes Negroes from the advantages of the law school it has established at the University of Missouri. It is manifest that this discrimination would constitute a denial of equal protection. The basic consideration is not as to what sort of opportunities other states provide, or whether they are as good as those in Missouri, but as to what opportunities Missouri itself furnishes to white students and denies to Negroes solely upon the ground of color. The question here is not of a duty to the state to supply legal training, or of the quality of the training which it does supply, but of its duty when it provides such training to furnish it to the residents of the state upon the basis of an equality of right. By the operation of the laws of Missouri, a privilege has been created for white law students which is denied to Negroes by reason of their race. The white resident is afforded legal education within the state. The Negro resident having the same qualifications is refused it there and must go outside the state to obtain it. That is a denial of the equality of legal right to the enjoyment of the privilege which the state has set up, and the provision for the payment of tuition fees in another state does not remove the discrimination. We are of the opinion that the ruling was error, and the petitioner was entitled to be admitted to the law school of the state university in the absence of other and proper provision for his legal training within the state. All right, so they're saying you gotta let the kid in, but they still kind of leave the door open for this idea of, okay, if you offer black students equal but separate facilities, it can still be legal. So, all right, hang on. We move on about 15 years. We hit Sweat v. Painter. Remember, the court has changed a lot now. Not only did FDR have like 13 years of packing the court with his own members, but then you get Truman in, and then Eisenhower. And while Eisenhower was pretty conservative, he still, at least let civil rights be, kind of, right? So, okay, we get a 9-0 reversal. So this is unanimous. And Chief Justice Vinson delivers the majority opinion. The question at hand here is, to what extent does the Equal Protection Clause of the 14th limit the power of a state to distinguish between students of different races in professional and graduate education in a state university? So, this man Sweat applied to UT, University of Texas Law School, and was outright rejected simply because he was black. And the lower court context is this. The state trial court recognized that the action of the state in denying petitioner the opportunity to gain a legal education while granting it to others deprived him of the equal protection of the laws granted in the 14th. The court did not grant the relief requested, however, but continued the case for 6 months to allow the state of Texas to supply substantially equal facilities. At the expiration of the 6 months in December of 1946, the court denied the writ on the showing that the authorized university officials had adopted an order calling for the opening of a law school for Negroes the following February. Finding that the new school offered petitioner, quote, privileges, advantages, and opportunities for the study of law substantially equivalent to those offered by the state to white students at UT, the trial court denied mandamus. The Court of Civil Appeals affirmed. Petitioner's application for writ of error was denied by the Texas Supreme Court. We grant cert because of the manifest importance of the constitutional issues involved. Give me 2 seconds, I gotta plug in my computer. All right, so just pressing this equal part of the separate but equal, right? They're saying, oh shit, we didn't let him in, and the court wants us to let him in, so in 6 months, we'll build a black law school and we'll call it equal, right? And the Supreme Court calls bullshit on this, right? They say, whether UT Law School is compared with the original or the new law school for Negroes, we cannot find substantial equality in the educational opportunities offered white and Negro law students by the state. In terms of number of faculty, variety of courses, and opportunity for specialization, size of the student body, scope of the library, availability of law review and similar activities, The UT Law School is superior. What is more important, the UT Law School possesses to a far greater degree those qualities which are incapable of objective measurement, but which make for greatness in a law school. Such qualities, to name a few, include reputation of faculty, experience of administration, position and influence of alumni, standing in the community, tradition, and prestige. It is difficult to believe that one who had a free choice between these law schools would consider the question close. So they call BS and they say you got to let the kid in. This is clearly not equal. All right, we move on. Same year, McLaurin versus Oklahoma State Regents is a 9-0, again, unanimous decision. The court has changed. I mean, we are seeing unanimous after unanimous after unanimous. So, okay. Chief Justice Vinson again delivers the majority opinion. Chief Justice Vinson was historically very strongly for civil rights. And he liked to write these opinions. Okay. In this case, we are faced with the question of whether a state may, after admitting a student to graduate instruction in its state university, afford him different treatment from other students solely because of his race. Man, this one's gross. So, McLaurin is a black man from Oklahoma who had earned a master's degree, and he applied for a PhD at OU, and he was denied simply because he was black. So the courts forced OU to change or Oklahoma to change their law, and they forced OU to admit McLaurin. But then they only offered to educate him under segregation rules, right? He was required to sit apart at a designated desk in an anteroom adjoining the classroom, to sit at a designated desk on the mezzanine floor of the library, but not to use the desks in the regular reading room, and to sit at a designated table and to eat at a different time from the other students in the school cafeteria. Like, geez, man. So the court says the state, in administering the facilities it affords for professional and graduate study, sets McLaurin apart from the other students. The result is that appellant is handicapped in his pursuit of effective graduate instruction. Such restrictions impair and inhibit his ability to study, to engage in discussions and exchange views with other students, and in general, to learn his profession. So they're saying, absolutely not. We're not having this. All right. Case 7, Brown v. Board, the big one. Again, it is a 9-0 unanimous decision. And we have a new Chief Justice because Vinson is gone. So Chief Justice Warren delivers the majority opinion. He states, in each of the cases, minors of the Negro race, through their legal representatives, seek the aid of the courts in obtaining admission to the public schools of their community on a non-segregated basis. In each instance, they had been denied admission to schools attended by white children under laws requiring or permitting segregation according to race. In each of the cases, other than the Delaware case, so this is a bunch of cases from all across the U.S., and they basically roll it all into one in this Topeka, Kansas case. In each of the cases, other than the Delaware case, a 3-judge federal district court denied relief to the plaintiffs on the so-called separate but equal document announced by this court in Plessy. Under that doctrine, equality of treatment is accorded when the races are provided substantially equal facilities, even though these facilities be separate. There was a 14th Amendment appeal, and they said, in the instant cases, that question is directly presented. Here, unlike in Sweat, there are findings below that the Negro and white schools involved have been equalized or are being equalized with respect to buildings, curricula, qualifications, salary of teachers, and other tangible factors. Our decision, therefore, cannot turn on merely a comparison of these tangible factors in the Negro and white schools involved in each of these cases. We must look instead to the effect of segregation itself on public education. To separate them from others of similar age and qualifications solely because of their race generates a feeling of inferiority. as to their status in the community that may affect their hearts and minds in a way unlikely ever to be undone. Whatever may have been the extent of psychological knowledge at the time of Plessy, this finding is amply supported by modern authority. Any language in Plessy contrary to this finding is rejected. We conclude that, in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal. Therefore, we hold that the plaintiffs and others similarly situated for whom the actions have been brought are, by reason of the segregation complained of, deprived of the equal protection of the laws guaranteed by the 14th. So they're striking Plessy, basically. They say you must integrate. And then the next year, in Brown v. Board 2, they say you must integrate with all due speed, which becomes problematic. Okay, so we move through basically 2 decades to 1970. And remember, um, Brown v. Board brought some serious issues, right? The National Guard had to be called in. There were riots and protests. There were riots in Chicago in 1968. People are furious, right? Malcolm X and Martin Luther King are assassinated in the early 60s. LBJ, Kennedy is assassinated, and his brother is assassinated. And then LBJ passes the Civil Rights Act. The Million Man March on Washington happens. Like, there's so much history here, right? And so we're moving through all of that to 1971, and we get again Swan v. Charlotte Mecklenburg Board of Education, and again a unanimous 9-0 decision. And Chief Justice Berger again delivers the opinion. Okay, so he says there are 4 main questions about Brown v. Board that we need to look at, right? Number 1, to what extent racial balance or racial quotas may be used as an implement in a remedial order to correct a previously segregated system. They say, our objective in dealing with the issues presented by these cases is to see that the school authorities exclude no pupil of a racial minority from any school, directly or indirectly, on account of race. It does not and cannot embrace all of the problems of racial prejudice, even when those problems contributed to disproportionate racial concentrations in some schools. So they're saying some schools, even though they're mathematically segregated, it's not segregated by law, right? It's just sort of the vicissitudes of where people live, and social issues and ethnic grouping, and et cetera, et cetera. They say awareness of the racial composition of the whole school system is likely to be a useful starting point in shaping a remedy to correct past constitutional violations. So they're saying, look, we can look at the numbers and it's a great starting point, but it's not everything. In sum, the very limited use made of mathematical ratios was within the equitable remedial discretion of the district court. So yeah, it's a good place to start. Number 2, whether every all-Negro and all-white school must be eliminated as an indispensable part of a remedial process of desegregation. And they say, where the school's authority proposed plan for conversion from a dual to a unitary system contemplates the continued existence of some schools that are all or predominantly of one race, they have the burden of showing that such school assignments are genuinely non-discriminatory. So they're saying, look, we know the history shows since Brown v. Board that what's happening is you're just closing down schools that would be right in the middle of, say, a white and a black neighborhood and would cause desegregation. And then you're just reopening schools, one in the black neighborhood and one in the white neighborhood, and claiming that, it's just, it's just because the neighborhoods are set up this way. They're saying, no, that's a problem. The court should scrutinize such schools, and the burden upon the school authorities will be to satisfy the court that their racial composition is not the result of past or present discriminatory action on their part. All right. Number 3, what are the limits, if any, on the rearrangement of school districts and attendance zones as a remedial measure? They say conditions in different localities will vary so widely that no rigid rules can be laid down to govern all situations. So they're saying this is really ambiguous. All right. Number 4, What are the limits, if any, on the use of transportation facilities to correct state-enforced racial school segregation? They're saying this is absolutely allowed by the courts. They say, the decree provided that the buses used to implement the plan would operate on direct routes. Students would be picked up at a school near their homes and transported to the schools they were to attend. The trips for elementary school pupils average about 7 miles, and the district court found that they would not take over 35 minutes at most. This system compares favorably with the transportation plan previously operated in Charlotte, under which each day 24,000 students on all grade levels were transported an average of 15 miles one way for an average trip requiring over an hour. In these circumstances, we find no basis for holding that the local school authorities may not be required to employ bus transportation as one tool of school desegregation. Desegregation plans cannot be limited to the walk-in school. So they're saying, nah, man, courts can force you to use busing. All right. And remember, this caused even more problems, right? People are pissed off in the South. And then we see sort of busing plans being implemented in Boston, which caused some real fury. So, all right, we're moving on. Keys versus School District Number 1 in 1973. This is a 7-1 decision that vacates the lower court opinion. And Justice Brennan delivers the majority opinion. And this is based on a Denver, Colorado desegregation plan. So they say there's really two problems from the lower court decisions. Problem one, the courts did not include Hispanics under the 14th Amendment. And they're like, what? Clearly, Hispanics are covered under the 14th Amendment, just like the Chinese and everybody else. They say the district court, in assessing the question of de jure segregation in the core city schools, preliminarily resolved that Negroes and Hispanos should not be placed in the same category to establish the segregated character of a school. We conclude, however, that the district court erred in separating Negroes and Hispanos for purposes of defining a segregated school. We have held that Hispanos constitute an identifiable class for purposes of the 14th Amendment. This is agreement that, though of different origins, Negroes and Hispanos in Denver suffer identical discrimination in treatment when compared with the treatment afforded Anglo students. In that circumstance, we think petitioners are entitled to have schools with a combined predominance of Negroes and Hispanos included in the category of, quote, segregated schools. So, yeah, Hispanics are part of the 14th Amendment, right? All right, problem two. The desegregation is a legal standard, right? And they say, in our view, the only other question that requires our decision at this time is whether the district court and the Court of Appeals applied an incorrect legal standard in addressing the petitioner's contention that the respondent school board engaged in an unconstitutional policy of deliberate segregation in the core city schools of Denver. Our conclusion is that those courts did not apply the correct standard in addressing that contention. Common sense, which is like, boom. They're taking a shot at the judges of the lower courts. Common sense dictates the conclusion that racially inspired school board actions have an impact beyond the particular schools that are the subjects of those actions. This is not to say, of course, that there can never be a case in which the geographical structure of or the natural boundaries within a school district may have the effect of dividing the district into separate, identifiable, and unrelated units. Such a determination is essentially a question of fact to be resolved by the trial court in the first instance, but such cases must be rare. In the absence of such a determination, proof of state-imposed segregation in a substantial portion of the district will suffice to support a finding by the trial court of the existence of a dual system. Of course, where that finding is made, as in cases involving statutory dual systems, the school authorities have an affirmative duty to effectuate a transition to a racially non-discriminatory school system. So they're saying, Denver, you gotta make improvements. All right. Moving on. Milliken v. Bradley, 1974. This is a 5-4 reversal, so we're getting closer, right? And Chief Justice Berger delivers the majority opinion. They say, We granted cert in these consolidated cases to determine whether a federal court may impose a multi-district, area-wide remedy to a single district de jure segregation problem, absent any finding that the other included school districts have failed to operate unitary school systems within their districts, absent any claim or finding that the boundary lines of an affected school district were established with the purpose of fostering racial segregation in public schools, absent any finding that they included districts committed acts which affected segregation within the other districts, and absent a meaningful opportunity for the included neighboring school districts to present evidence or be heard on the propriety of a multi-district remedy or on the question of constitutional violations by those neighboring districts. Okay, that was a lot, right? They're saying, all right, I think this is Detroit. So Detroit's inner city is under one school district system, while the suburbs around them are under multiple school district systems. And basically, the lower courts said, well, the suburban districts have no segregation policies. They're not trying to enforce segregation. Um, But the lower court still said that because the urban segregation is so high, even though they're their own school districts, that they have to merge under this like super school district system, and like bus kids out of the city into the suburbs and vice versa. And the Supreme Court's like, no, I don't think we can have this. They say here the district court's approach to what constituted actual desegregation raises the fundamental question not presented in the Swan case as to the circumstances in which a federal court may order desegregation relief that embraces more than a single school district. The court's analytical starting point was its conclusion that school district lines are no more than arbitrary lines on a map drawn for political convenience. Boundary lines may be bridged where there has been a constitutional violation calling for inter-district relief, but the notion that school district lines may be casually ignored or treated as a mere administrative convenience is contrary to the history of public education in our country. No single tradition in public education is more deeply rooted than local control over the operation of schools. Local autonomy has long been thought essential both to the maintenance of community concern and support for public schools and to the quality of the educational process. The metropolitan remedy would require, in effect, consolidation of 54 independent school districts, historically administrated as separate units into a vast new super school district. Entirely apart from the logistical and other serious problems attending large-scale transportation of students, the consolidation would give rise to an array of other problems in financing and operating this new school district. We conclude that the relief ordered by the district court and affirmed by the Court of Appeals was based on an erroneous standard and was unsupported by record evidence that acts of the outlying districts affected the discrimination found to exist in the schools of Detroit. So saying, no, we're not having this forced merging of school districts. Absolutely not. Okay, case number 12. Pasadena City Board of Education v. Spangler in 1976. It is a 6-2 vacated and remanded opinion, which means they kick it back down. Basically what they said is we're not holding the standard of the lower court. We're going to give you some advice, kick it back down to you, and let you hear the case again. All right. Justice Rehnquist delivers the majority opinion. Petitioners requested the district court to dissolve its injunctive order requiring that there be no school in the Pasadena Unified School District with a majority of any minority students enrolled. The district court refused this request and ordered the injunction continued. It was apparently the view of the majority of the Court of Appeals panel that this failure to maintain literal compliance with the 1970 injunction indicated that the district court had not abused its discretion in refusing to grant so much of petitioner's motion for modification as pertained to this aspect of the order. We think this view was wrong. So basically, what happened was the Pasadena Unified School District had in its sort of desegregation plans this rule that said, where was it? There can be no school in the system with a majority of minority students enrolled. So they're saying we don't want school systems with 50% or more of minority students because that is approaching segregation, right? And the courts are like, no, just no, right? They say that's fine, actually, right? The lower court getting rid of that piece. Um, They say, we think that enforcing its order so as to require annual readjustment of attendance zones so that there would not be a majority of any minority in any Pasadena public school, the district court exceeded its authority, right? They're saying, so the district court said every single year you have to look at the numbers and make sure that there's not more than 50% of minority students in any single school district, right? Every single year you have to do this, which is, kind of expensive and a pain, right? So they say the fact that Black student enrollment at 5 of 32 of the regular Pasadena schools came to exceed 50% during the 4-year period from 1970 to 1974 apparently resulted from people's randomly moving into, out of, and around the Pasadena region. This quite normal pattern of human migration resulted in some changes in the demographics of Pasadena's residential patterns, with resultant shifts in the racial makeup of some of the schools. But as these shifts were not attributed to any segregative actions on the part of the petitioners, we think this case comes squarely within the sort of situation foreseen in Swan. No one disputes that the initial implementation of this plan accomplished that objective. That being the case, the district court was not entitled to require the PUSD to rearrange its attendance zones each year so as to ensure that the racial mix desired by the court was maintained in perpetuity. For having once implemented a racially neutral attendance pattern in order to remedy the perceived constitutional violations on the part of the defendants, the district court had fully performed its function, providing the appropriate remedy for previous racially discriminatory attendance patterns. Okay. You know what? We're just going to stop there. That's enough. They just get into more of the nitty gritty from there, but you get the point. Thanks so much for being in my class. Thanks for attending, and thanks for being patient. I hope you have a wonderful summer. I am teaching a political theory class in summer 2, which I would love to have you involved in. And then I'm teaching many courses in the fall again, so I'd love to have you there. So have a wonderful summer. Please be careful. Please take care of yourselves and your families. And I hope to see you soon. Bye.